Good morning, everyone. I'm Hallie Zobel. I'm here for your podcast this morning. I'm a Central Florida attorney working at CPLS. We can be reached at 877-647-7887. Today, we're going to be talking about requirements for a last will and testament. Remember, guys, I just practice in Florida. And every state has different rules for their last will and testament. And that's a question I get a lot. Hey, Hallie, I just moved from Colorado. Do I need a new will? Well, maybe, maybe not. Let's look at it this morning. So, in Florida, you're allowed to write your own will. Many individuals do that. But your will has to be in compliance or conforming to Florida law. There's so many nuances in Florida law, it's best practices to hire a lawyer who handles these type of matters. I practice estate planning law, guardianship law, and probate law. So, you can absolutely buy a will off the internet, but do you really know what you're getting? I'm not a fan of that, of course. Has it been drafted by a lawyer from your state as part of the form that you buy? Do you get a consultation with an attorney? When you hire an attorney, you get to talk to them face to face. Might not be able to with your online will. So, can your consultation include your unique family situation? Maybe, maybe not. Maybe you want to disinherit someone. Do you have a child with special needs? You may very well need custom drafting of your will. Do you have any idea how many witnesses Florida requires? Yes, sir, that's correct. 2 witnesses. They have to watch the testator sign the document and be in the presence of them. Well, what's a testator? That's just a fancy term for the guy who signs the will. The female version of that is testatrix, and these words come from common law, where our law comes from, England. So, testator can be used for male or female. Did you know you have to be over the age of 18 to sign a will? You got to have capacity to sign a will. You can't be incapacitated. Did you know your agent can't sign your will for you? Just because you tell someone, a dear family member, what you want to happen when you die, that doesn't cut it, folks. That is not a will. Florida does not recognize an oral will. You must sign at the end of your will in Florida, and you can put it in your own handwriting, like I mentioned, but it has to comply with Florida law. Now, let's talk about notarization. This one's always tricky. Does it have to be notarized or does it not? Tricky because a will is still valid in Florida if it's not notarized, but it's preferred to be notarized. That's called self-proving. Why do we want it self-proven? Because then when the person who executes the will dies, we don't have to find the witnesses and have them sign an oath that they watched the testator sign. We've already done that on the bottom of the will and submitted it to court. So, and I've never met a witness yet that really wants to go down to the local courthouse and see the clerk and sign an affidavit and take off during their workday, right? So we're thankful that the witnesses watch the testator sign and serve as a witness. We don't want to alienate them further years down the road and make them go give another oath. So at our law office, we go ahead and notarize the will. The witnesses sign and swear that they watched the testator sign and they were in the presence, and the testator swears that he or she watched the witnesses sign. We live in the technology age. Let's talk about an electronic will. That's a popular question that we get at our law firm a lot. Does Florida recognize electronic wills? Well, we do. The issue isn't the electronic will. Very few attorneys are drafting them. Why do you think that is? Well, yes, they are acceptable, But the statute requires certain formalities in storing these wills, and where are they going to be kept? So there's very few companies in the state of Florida that are actually storing the original wills on a computer to follow all the nuances of the Florida law. So because I don't know of any companies doing it who are storing the wills, people aren't having the electronic wills done. Yes, it would be so much simpler to do a DocuSign. I bet you've heard of DocuSign. Well, the reality is that we attorneys are not drafting these right now because we don't have the companies to store them properly. Think about how technology has changed. 20 years ago, we might have been storing this on a VHS tape or a CD or a floppy disk. So who knows what we'll have 20 years from now. The safest way seems to be stick with your paper original last will and testament. Keep it in a safe place so it can be, your loved ones can file it with the court upon your death. Thanks so much for tuning in today to Law Moment. My name again is Hallie Zobel. I encourage you to call us at 877-647-7887 or to email me hzobel, Z-O-B-E-L, at cplspa.com. And that's all for today.